Mr. Germerthy, I think we're connecting with Mr. Law right now. I guess while we're waiting for them to connect, Ms. Wilkerson present.
She is.
On the record, this People versus Samantha Wilkerson. This is file number 245351. The record just reflects Ms. Wilkerson present here in the courtroom today.
Sierra Coke on behalf of the people.
They got a right for the school for some reason.
Mr. Germerthy, yesterday I received, I believe, a notice that there was going to be a plea today.
All right, there'll be a no contest plea. We did submit for the court's review. I think it was Stokes' office and the police report. I submitted the transcripts of the exam. The plea offer is still an added count to domestic violence under 769-48 deferral. The other counts would be dismissed. There's also an agreement that there will be no upfront jail. This will remain a non-public file on this Wilkerson is on probation goes to the deferral public.
Okay. Ms. Koch, is that a correct statement of the plea offer?
It is, Your Honor. She has no criminal history. We have met with the victim, and everyone is in agreement that this will be the plea if the court will accept it.
Ms. Wilkerson, have you had an adequate opportunity to talk to Mr. Germerthy about this?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Thank you. Lower your hand. Ms. Wilkerson, you're not on any kind of probation or parole?
No, sir.
Okay. And you understand that the maximum possible penalty for the charge of domestic violence is up to 93 days in jail?
Yes, sir.
With that in mind, what is your plea to that charge today?
No contest.
Okay, right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading or no contest.
Yes, sir.
Has anybody threatened you with anything to get you to enter this plea?
No, sir.
Has anyone promised you anything other than what we said here on the record today?
No, sir.
Is it your own free choice to enter into this plea?
Yes, sir.
I did have a chance to review the police report prior to today's hearing. Ms. Cope, have you reviewed that report?
Yes.
Do you agree that it would provide a factual basis for finding of guilt as to domestic violence?
Yes.
Mr. Germerthy, have you also reviewed that report?
Yes, Judge, and I would also agree that it would provide factual basis of a lesser charge.
So the court is going to mark and admit that police report as Court Exhibit 1 and use that as the factual basis. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
I think Mr. Germerthy said it, but this will be dismissed under 769-4A if she's successful on probation, and everybody expects that she will be. So I just wanted to place that on the record. Thank you.
Mr. Germerthy, are you aware of any other threats, promises, or inducements?
No, Your Honor, nothing other than what was stated on the record. And then I should also state the reason for the no contest plea is potential civil liability and others pending child custody issue, family division.
Okay, and we didn't make a record, but Ms. Koch, you don't have an objection to the no contest plea for the reasons stated?
No.
Ms. Koch, are you satisfied that the court has complied with statute for role in the taking of this no contest plea?
Yes, Your Honor.
Yes, sir.
Ms. Wilkerson, the court finds that your plea is knowing and voluntary. The court is satisfied based on support exhibit 1 that there is a factual basis to support a finding that you are guilty of the charge of domestic violence. The court will accept the plea today. I would like to set this for a separate date for a sentencing hearing. I'm not aware of any factors that would cause the court to go outside of what the parties can agree to in terms of the 764A probation, but I would like just PSI so that I can understand the facts here. So Ms. Wilkerson, you're just going to meet with the probation officer just to set up a pre-sentence before you leave today.
Okay.
And then it's just important to stay in touch with Mr. Murphy prior to the next court date, okay?
Yes, sir.
In light of the plea today, the court will also adjourn the trial that was set for, I believe, next Thursday. Spoke anything further we need to address?
No, thank you, Your Honor.
No, sir.
Thank you, that's all. Okay, Mr. Law, do you have the ability to unmute on your end there?
Yes, sir.
Are you able to hear me okay?
Yes, Your Honor.
Okay. On the record, we have 2 files. We have the felony file, which is 25-5382FH. And then we have the district court file, which I'm sitting presiding over by assignment. That is file number 2417615. The felony file is a new charge. The district court file is a probation violation. Mr. Murphy, can you give me a status of each of these matters today?
Just before Mr. Law was sentenced in his pending matter in Grand Traverse County, we had good contact, and we were, from my understanding, we were very close to having this case resolved. That's where I still stand. But since he was in Grand Traverse County and then moved to Benzie County, the contact has been terrible with those 2 counties with Zoom or even trying to set this up with Mr. Law. So I think I would ask for an adjournment. And then if we can have Mr. Law then appear here in person, and again, I'm going to try to at least make contact with him in Benzie County. There, it's difficult to schedule something with Zoom or otherwise, and I don't know why. But it's never been an issue. It's just been an issue with getting Mr. Law. At least from it's not from Mr. Law's perspective or my perspective, but I think that jail is a little difficult in setting up those Zoom meetings with him. So I would just set this for a jurisdictions conference to the next the court's next motion date, but I anticipate a resolution.
Ms. Cope, do you have any objection to that?
No, but at that hearing, the plea offer will be revoked. It was made 2 months ago. The plea offer, as put on the record, was count 2, ag stalking, and added count 3, domestic violence second, dismissed count 1, and that's for the felony file. Ms. Chady is handling the misdemeanor file.
Ms. Chady, do you have any input on the request here as to the misdemeanor probation violation?
I guess to further clarify, is Mr. Garamuthi asking for a further adjournment of the district court probation violation hearings as well?
I would, Judge, once there's a plea in the circuit matter, that would just resolve the underlying offense, because that's what stemmed with the violation. So it would just resolve itself. So we'll have it again all set at the same time.
Your Honor, I'd object to that adjournment for these probation violation hearings. On January 21st, Mr. Law was arraigned on the first probation violation, and then this hearing was set. So we've had about 6 weeks at this time that Mr. Law has known about the first violation for this hearing. The people are prepared to do this hearing. There was also a subsequent probation violation that was filed that Mr. Garamuthi is aware of, and Mr. Law should be aware of his conduct while he's been lodged of continuing contacting the victim. So I think those hearings should be held today. Thank you.
All right, well, I mean, I'm aware that Mr. Law was recently moved to Benzie County for Grand Traverse, since I think I signed the writ for his appearance today, late yesterday. So I think there's a reasonable basis for counsel to need to speak to Mr. Law, and I think it's reasonable to conclude that he hasn't been able to due to Mr. Law being moved around. Because I believe he was moved to Benzie because of overcrowding
Overcrowding,
at Grand Traverse jail. So I can't fault Germany for issues that are unrelated to his representation, his ability to be prepared today. So I think his position is shady. The court is going to grant the request for adjournment. Court will set both of these together for a hearing. Mr. Murphy, at that next hearing, you need to be prepared to go forward with a contested hearing on the probation violation if it's not resolved on the plea at that time.
And if we can check with Mr. Law, I think he should be out in the next 30 days. I think so. So he should be able to be here in person by then.
Well, the court's going to set it as an in-person hearing. Mr. Law, if you're released, you need to be here in person. If he's not released, Ms. Coke, I'm going to ask that the people prepare a written version in person so that we don't have any issues regarding communication. He's here in person. That shouldn't be a reason why we can't go forward. That's how we'll proceed. Ms. Coke, is JD further today?
Nothing further.
No, thank you, Your Honor.
No, sir.
Mr. Law, do you have any questions at all?
No, Your Honor.
That's all for today. The court's going to disconnect from Benzie at this time. Is Mr. Shiplet present?
What is your view? Or you do stuff? I think we're ready because I don't know if this is going to be resolved. I think
The court will call People versus Shiflet, file number 255373. The record should reflect that Ms. Shiflet is present here in the courtroom today. This is the date and time set for sentencing. If I could, counsel Shiflet.
Sierra Coke on behalf of People.
I think you're ready to go.
Thank you. Ms. Shiflet, have you had a chance to go through the pre-sentence report and speak to Mr. Murphy about that?
I believe so.
More time to do that before we go forward here.
I haven't really talked to him much since like maybe a month ago. I don't know.
We did talk like 2 weeks ago about our pre-sentence report. We did go over that. I don't know if there's any addition since then she needs to speak with me about.
Maybe a little bit, yeah. I've been doing things.
Okay.
Yeah, sorry.
All right, is Mr. Beckman present? Can we take Mr. Beckman's case?
Beckman. Mr. Beckman's here.
Okay, so we'll just pass Ms. Shiflet for the moment. Mr. Beckman, if you can come forward to the podium, please. This is People versus Jeremiah Beckman, file number 255378. Mr. Beckman is present here before the court today. Mr. Murphy, can you tell me the status of this file?
Your Honor, this, just so the court's aware, this isn't being handled by my office.
The Attorney General's office should be on.
They are, okay. Thank you. Mr. Wood, if you could unmute, please.
Sorry, Judge. Good morning, Your Honor.
Good morning. We're on the record now in People versus Jeremiah Beckman. Is that the file that you're signing in on?
It is, Your Honor.
Okay. If you could put your appearance on, Mr. Wood, please.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the People.
Thank you. Mr. Beckman's present here in the courtroom along with his counsel, Mr. Kermurthy. Mr. Kermurthy, can you tell me the status of this file today, please?
Yes, Your Honor. I've been dealing with Ms. Messer from the AG's office on this matter, and I believe around 5:20 or so yesterday, Mr. Wood emailed me indicating that he was covering this case. The discussions I've had with Ms. Messer, and I simply state that because I don't know if that's changed with Mr. Wood's position, but there was an offer that was tendered where Mr. Beckman would plead to count 1 and count 2 would be dismissed. But in further discussions with Ms. Messer, she was willing to offer a disorderly person. In other words, it would be placed on a delay if the bond amount and some additional monies that Mr. Beckman would be able to pay and get caught up with, I think, almost $4,000 worth of arrears, and then continue paying his monthly obligation. Ms. Messer would agree to put him on a delay, so he would make those monthly obligations for a year. And then at the end, that would end up with a disorderly. I've discussed that with Mr. Beckman. I think he's working towards coming up with those funds. He has $1,000, including the bond amount that's already posted, to go towards that request of at least coming up with that $4,000. But I don't know if that's Mr. Wood's position at this point or not.
It is. I'm wondering, so he paid $100 in February only. He's got a $490 a month obligation. So he's got $1,000 today. And how much is the bond? It was a cash bond posted in his name?
Correct. The bond amount is $4,221. But if he posted it, we would keep that if you're ordering restitution, but it would be applying to fines and costs.
Okay, so the 44221 is cash posted in his name, and he wants to pay that over to the child support case.
We will.
Mr. Gurmurthy?
Yeah, we'll keep this bond and apply it to fines and costs and restitution.
So in other words, Mr. Wood, it would be, the balance would be applied to the arrears minus whatever the fines and costs would be in this case.
Well, it's kind of a chicken and egg type situation because we want to know how much is getting paid in. We want, I mean, he's got to get his arrears down to $20,000. This is what my notes say. His current arrearage is $28,631.50. So the 4221 would be a good step. Another 1,000 would make it 5221. He needs, about another $3,000, but that's assuming this bond is paid over. I mean, we do these a lot where I understand that the court needs its fines and costs. What we're asking is that with the defendant and his attorney's permission, and the judge allows it to pay that bond over. We would provide the court with an order that says that 4221 is paid into his child support case, and that, otherwise, unless he comes up with money in a different fashion, again, he's got an arrearage of $28,631, and he needs to get down to $20,000 in order to get the delayed sentence if he wants to try and avoid the felony. So there's, again, a variety of ways that can happen, but we would like to see the bond paid over to start, and then it's $1,000, and then maybe set this over, Judge, for 30 or 60 days. If he gets it down to 20 grand, fine, he pleads, and we do the delay.
Okay, Ms. Lee, was there anything you wanted to add?
No, I believe Attorney General Mitchell Wood addressed the concerns that the arrearage, because of the bench warrant was originally issued, it was like 3 years ago with a lesser amount and has accrued monthly. So the 28,000 and some odd dollars, 631, that is correct.
Oh.
Yes, and additionally, I also agree with the Attorney General. Generally, when a bond is posted, front of the court does request that the money be transferred and applied to the child support account, because that is due to the mother and the child.
Because this is a criminal case, if you order the 4221 as restitution, I would apply to that bond to the restitution and make that payable to the court.
Okay.
Well, I'm not
Judge,
talking
Mr. Beckman-
restitution, Judge. I'm sorry.
No, go ahead, Mr. Wood, go ahead.
I'm not talking restitution. It would be an order, again, a standard order. The AG, we've been doing them for 20 years. That simply says this bond, this 4221, and you sign the order that says pay that bond. The clerk of the, whoever handles the bonds cuts a check to the front of the court, sometimes just walks it down there to pay that bond over. So you convert his bond to a personal recognizance bond, and the cash bond is paid over. I mean, that's what we're asking. Restitution is after sentencing, whereas this is an order paying the bond over. It's, again, Judge, we've done it many times. And if both sides aren't opposing it, we, there's nothing stopping, and it's what we, to my mind, it's what should happen in these felony non-support cases. You post a cash bond, it automatically, there's a few courts that it kind of happens that way, that it automatically gets shifted over, but we would like to see that bond paid over, and then again, set the matter over to see if we can get it down to 20,000.
Okay, so what I'm gonna do then is modify the bond in this case to a personal recognizance bond, $1,000 personal recognizance bond. The court will order that the bond that was previously posted be applied to the arrearages submitted to the front of the court. The court will set this for a plea hearing in 60 days. And we'll see where we're at that point. And if the AG's office is on the table based on what Mr. Beckman has done between now and then, we'll enter the plea. If not, we can see where we're at and whether or not a plea agreement is going to be possible.
And just for the record, Mr. Beckman doesn't object to what the court did. I was going to suggest that that's what the court do, so the bond can be applied. He has $1,000 today. He indicates he could come up with another 1,000 by next week, and then perhaps something more in the next 60 days. So I think that should bring us down closer or below that $20,000.
I can get it paid below the 20,000 in 60 days.
Okay.
I think then that would be beneficial, and we can then go forward with that plea. Mr. Wood, are you going to be on this case going forward, or should I deal with Ms. Massa going forward?
The way it works is I'm a special assistant AG now. I retired from that division. I actually ran this unit before I retired. And so not necessarily. You should speak with Ms. Messer about it. But I send them a note laying all this out, so she'll know exactly what happened today. And
Okay,
my question, Judge, do you need the AG to prepare the new any documentation regarding the PR bond? They will send you an order paying that bond over. That now that we've put it on the record, I assume we'll send you a copy, Mr. Groomworthy, but we'll just send the order directly to the judge. But do you need a bond modification from the AG, or will the court do that?
Nope, I've already, just as you've been talking here, I've pulled out the new bond and signed that, so that is in effect as of right now.
All right, and the notice of hearing will come from the court regarding the adjourned hearing.
Correct, and the AG can appear by video as you're doing today for that hearing.
Wonderful. Thank you very much, Judge. Thank you, Mr. Gurumudi.
All right, thank you, Mr. Wood. Thank you, Judge.
Thank you.
Mr. Beckman, just make sure that you stay in touch with Mr. Gurman.
Oh,
over the next 60 days. Okay?
Yes.
All right.
And I'm going to step out of the shift, please.
Thank you.
So let's take a short recess and, or Mr. Isles, are you ready with your case?
Yes.
You are, okay. We'll call, Evil versus Sylvester. This is file number 245367. Sylvester, and you can put in there. I can have counsel with your.
Sierra Coke on behalf of the people.
Scott Isles, on behalf of Alex Sylvester, standing to my left.
Yeah, Your Honor, we're just going to ask for a 30-day adjournment. We anticipate a dismissal on this case. Mr. Isles dropped off a check for the amount of money that was due under the contract. We are sending that out to the victim. It's a cashier's check, so we don't expect any problems, but as soon as our victim lets us know it's gone through, we're going to file the dismissal.
Works for me, Your Honor.
Okay. Do you have any questions?
Am I able to go to Tennessee for spring break in 2 weeks?
Oh, yeah.
It should clear by then, but
Yeah, and he has sole custody of this child. So it's
Hope you have any objection to a modification of bond if this is not discussed prior to that time.
No.
So I'll just leave that to counsel if it's not valid before then, submit a stipulation, modify bond.
thank you, Your Honor.
All right, thank you.
Okay, we'll take a short recess. We'll go back on the record about. we'll go back on the record in People versus Shiflett. Shiflett, you come forward, please. Shiflett, did you have opportunity to speak to Mr. Murphy about the pre-sentence report?
Yes, Your Honor.
Mr. Murphy, just for the record, I am in receipt of a couple attachments, one from the pretrial services supervisor, Ms. Anderson, and one from the recovery court, I think it's Sheboygan. Aside from that, are there any additions, deletions, or corrections to the report?
And I did send the order of discharge from probation from her.
Oh, that was in there too. Yeah. I did
From
see
her
that.
case of, her case with samples, so. Okay, and I simply said that because there was that correction on CLJ 284A, page 2, under the recommendation narrative, where it states that in the middle, she was also not successful on a previous felony probation term. But the order for discharge indicates that she, the conditions of probation were successfully completed.
Alda, is that?
I mean, she had previous violations, I believe, that the new case took place. But I mean, what Mr. Murphy says is accurate. I mean, the discharge says, successful.
Okay, so I'll have the PSI just be amended to reflect that she did successfully complete her previous probation. Although you're indicating there were some violations during that term.
That's correct.
So I think it's fair to include all of that information, so.
Okay.
Hold on a second. Recording just. Starting number 1, 3 quarters.
Yeah, it keeps going back and forth.
Yeah.
I know we've had the mics change colors and it still records, but
We need to-
Not sure. It looks like it's still recording. Is there a message and then this keeps changing? Got it.
I know we still recorded those blank on the second. Yes.
Okay, we can continue. I'm not sure where we left off. Were there any other corrections, additions, or deletions?
Oh, yeah.
Are there any challenges to the scoring of the guidelines?
I believe the right word is over 17 months. Judge.
I'm sorry, Ms. Polk, are there any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
Anything on behalf of the people for allocation?
Your Honor, I spoke to the MDSC officer that did the recommendation. The offer or the recommendation here was 45 days jail, no probation. She's on probation in other counties, so it doesn't make sense to double her up on probation. She's had some previous absconding. I think she absconded for 10 months and she had some difficulty. This is at the very low end of the guidelines. We'd ask the court to follow the recommendation. Thank you.
Sure.
Thank you. Ms. Schiffler currently is not on any probation. She's going to a recovery court in Sheboygan County. I submitted the referral I believe the referral went in this week. She has an assessment scheduled next Tuesday at Harbor Hall for recovery program in Sheboygan County. I spoke with her attorney, Ms. Libby, who's representing her in Sheboygan County. All of those things are true. I have a correspondence with her that she's getting into recovery court up there. Ms. Shiflett is a young individual. She's 23. Ms. Shiflett indicates that she has minor children. She is taking some steps to change her lifestyle at this point and make some strides to better her life for children, get into the recovery court program. She needs some help with addiction and addiction treatment. So for all those reasons, I would simply ask again, the court would hold any jail time in abeyance, put her on a short probationary period here while she gets into recovery court and continues with that. We think that's important for her is to make these assessments, and she's done all of those things. She's maintained contact with recovery court up north. She's gone to her assessments, and as the report from pretrial supervision indicates, she has been 100% compliant. I think this is the best Ms. Shiflett has been while under the supervision of the court. So I think giving her the benefit of not incarcerating her today and allowing her to comply and complete with recovery court is certainly helpful for her for the treatment purposes that she's seeking. That's all I have, Judge.
Thank you. Ms. Shiflett, anything you want to say?
I just completely agree with him. I'm trying to get my life together. I have a 2-year-old son. I'm a single parent. Just trying to do better. That's it. Thank you.
Okay. All right. I mean, there certainly are indications that you're trying to address your underlying issues, which is important. And I think the treatment courts generally give people a good opportunity for success. So that's definitely positive. It works in your favor. So I hope you can follow through with that. Difficult program generally, but it does give you a lot of tools to be able to deal with things going forward.
Thank you.
You know, we still have this case here, which is completely separate. The guidelines here are 0 to 17 months. I think the mitigating factors like you seeking to participate in the treatment court, your lack of any positive tests while you've been on bond in this case, all I think mitigate this and lead the court to a sentence at the lower end here. And I think that's in line with what the recommendation is. However, I do think there does need to be a consequence for your behavior in this case. I think 45 days in jail is again the very low end of the guidelines. I think it's reasonable. I think it accounts for your past history and what happened in this case, provide the consequence to that. So I think it's a fair recommendation. The court is going to follow that. Court is going to sentence you to 45 days in the Crawford County Jail. You do have credit for 1 day served. Court is going to order a crime victims assessment amount of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You have the ability to seek an appeal of this sentence. Mr. Germurphy.
I did go over a lot of paperwork and give her a copy of the judge.
Good luck to going forward.
I love you.
This is Patrick Ross, case number 45352.
Sierra Coke on behalf of the people.
Sir, is your name Patrick Ross?
Yes, it is.
Oh. Mr. Ross is present here in court today. Mr. Ross, did you have an opportunity to go through the pre-sentence report with Mr. Germurphy? Yes, I did. Mr. Germurphy, are there any additions, deletions, or corrections to that report?
No, Your Honor. I think it's, the body of the report is accurate, and also the guidelines are 0 to 9 months.
I do want the record to reflect that in this case, I also received a report from Ms. Anderson, Services that indicates Mr. Ross has been in compliance 100% with his bond conditions. Ms. Cope, do the people have any additions, deletions, or corrections?
On the front page under misdemeanors, Mr. Haven forgot to type in a number there. I checked with him yesterday. The number of misdemeanors is 16.
Mr. Chairman, if any objection to that? change?
No.
Okay. Court will order that the report be amended to reflect that. Any other changes? Let's go.
No, Your Honor.
Any challenges to this warrant?
No,
Do you have any victims that wish to address the court today?
no.
Anything on behalf of the people for allocation?
Your Honor, I've struggled with whether or not jail time is appropriate for somebody who has 3 prior felonies and 16 prior misdemeanors and had a firearm. We talked about this at the last hearing in terms of when he did the plea. Under 750.83, it is required that the gun be forfeited. So we'd ask the court to order that. And I do think a short jail stint for 5 to 10 days is appropriate, given his behavior in this case. I mean, he should have known that he, could not possess a firearm, but did anyway. Thank you.
Your Honor, on behalf of Mr. Ross, I believe the last time he was in any serious trouble was in 2017, so just about 8 years or so, he's been put out of trouble. The incident here stems from some teenagers bothering Mr. Ross, and he ring the doorbell, knock on the door, just antagonizing him, and he let it go for a while till he scared them away, and again, it was a firearm that he had. When the officers arrived, Mr. Ross is very honest, very cordial and open, and indicated what happened. I think the officer sided with Mr. Ross as to how harassing his behavior was. And then in conversations, Mr. Ross did admit and tell him that he had a gun and he scared them, which that suddenly led to this. And I say that because again, Mr. Ross was not trying to hide anything or not be honest or open with the officers. And then, of course, it's come to court and it took care of the issues here with court by pleading to his violations. I don't think Mr. Ross is challenging the forfeiture action of it, but I think his family is trying to get the heirlooms back or the guns back. And they have filed for the necessary paperwork to go through with getting those family heirlooms back. I think the law doesn't preclude them from doing so. While on bond, Mr. Ross has complied with pre-trial supervision. So when looking at his history, Mr. Ross has always successfully completed probation and has been monitored well. So I don't anticipate any of those issues going forward with Mr. Ross either. Also, according to Mr. Ross's medical condition at one point, we had this matter adjourned for a June status conference because Mr. Ross was going through some surgery. It certainly has some medical conditions that he's still dealing with. I think the recommendation is appropriate to hold him in jail time in advance, and not in concert with Mr. Ross doing this medical history, given his behavior while on bond condition, his behavior with the officer, being open, honest, cordial, and essentially telling the officer what he did was wrong, and accepted his wrongdoing and how he handled it. He should have suddenly just called the police and handled it that way. But I think Mr. Ross tried to ignore the issue with these children and these are teenagers and tried to ignore the issue of being harassed by them, and then just took things in his own hands, which he should have been done. So I would just ask that no jail at this point be ordered and jail time in advance. And Mr. Ross should just comply with terms of probation, which I don't believe will be an issue for him.
Mr. Ross, anything you wanted to say today?
No, that should cover it, Your Honor. I mean, like I said, I had a medical condition and I was kind of, fearing for my safety. And not only did this one gentleman come over and trespass in my yard 3 times, I asked him to leave. Then he came back again with 2 more acquaintances. And that's when I, proceeded to try to scare them off. And like I said, I guess I was in the wrong in doing so.
Yeah, so I read through the report. I'm familiar with the information in the report in terms of what happened in the circumstance. There's also a lot of information there about your background and your history and circumstances. I take all of that into account along with what we're going to say here today. And you're not the first person in the history of time to be harassed by teenagers, right?
Well, yeah.
Good or bad, and excusable or not, it's the kind of thing that happens. And as an adult, it's incumbent on you to address that situation in an adult way.
Right. Well, one of my problems.
I turn.
Oh, I'm sorry.
Yeah. Not in a a teenage way, which is to come out with a gun to try and scare them off. If you were, and I think the report is exactly right. If you were truly in fear of your safety, the thing to do is to call the police, have them come take care of it, not take matters into your own hands. And coming out with a firearm, whether it was loaded or not, nobody else knows that. And trying to scare people off with firearms is just the wrong way to go. So there are many different ways that you could have handled this situation. I'm not saying the kids were right for doing what they were doing. They probably weren't, and they probably, deserve some consequence for their actions. I'm not saying that at all. What I'm saying is your way of dealing with wrongful behavior by other people was not right either.
I understand.
You're the one who's an adult. You're the one who's supposed to be more mature to make better decisions. And you didn't do that. So I think there's a consequence to be paid for that. I think that the probation is the appropriate way to do that with jail held over your head. I think looking at this circumstance as a whole, I don't feel that at the front end it requires jail time. But I am going to hold jail time in abeyance. I want you to be clear that if you don't comply with your probation, and I do have some concerns about that, even though you have successfully completed probation in the past, a lot of your previous offenses are just kind of not following the rules kind of things. So I want you to be clear that you are going to be held to the conditions of your probation, and that if you don't comply, then I will impose jail time, and your health or anything else isn't going to stop that, because what you'll be telling me at that point is your health isn't as important to you as staying up with your probation. So none of that will be an excuse to avoid jail time forward. You have health conditions that jail is fully capable of accommodating those. So I just want you to be clear that while I don't think upfront jail is warranted, if you don't comply with probation, I will certainly impose jail. So the court is going to place you on probation for a period of 18 months. The court's going to adopt as the conditions of the probation all the terms and conditions listed in the report. The court is going to impose 6 months in the Crawford County Jail with credit for 2 days served. The court's going to hold that time in advance to be served at the discretion of the court. The court is going to order a crime victims assessment of $130. Court costs of $325, attorney fees of $350, $68 state cost, supervision fee while you're on probation of $30 per month. You have the ability to seek an appeal of this sentence, and Mr. Murphy's going to provide some papers to you that explain to you what your appellate rights are. Mr. Murphy, just have Mr. Ross accept.
Yes, Your Honor. For the record, I did go over Mr. Ross's appellate rights, and he has his appellate paperwork as well.
Thank you. And then Mr. Haven, are you meeting with Mr. Ross here?
Yes.
So just touch base with Mr. Haven before you leave.
And Your Honor, is the gun forfeited?
Yeah, the court is required under statute to order that. I'm not, of course, ruling one way or the other on anyone else's rights to recover those weapons.
Right, thank you.
Because that's not a matter before me today. Thank you. Good luck to you.
Thank you, Judge. Judge, Mr. Cleo is here, but he handed me a couple of papers this morning that I want to make copies for the court's review, so I need a couple of minutes.
Okay, we'll take short recess. If you can get those to Sarah.
I will, yes.
All right, please.
Ms. McGregor, are you able to hear me okay?
I am, Your Honor.
Okay, thank you. Let's see. Let's go on the record in People versus Brandy Welch. This is file number 235271. If I can have counsel put your appearances on, please.
Christy McGregor, Special Prosecutor for Crawford County.
Thank you, Your Honor. Jason Thompson, attorney for Brandy Welch.
Thank you. This is the date and time set for a sentencing hearing in this matter. Ms. Welch, have you had an adequate opportunity to go through the pre-sentence report and speak to Mr. Thompson about that?
Yes.
And Mr. Thompson, just for the record, I'm just going through them here. I received a number of letters on behalf of Ms. Welch prior to the hearing today. I have from the Grace Center, I have a letter from Ms. Welch's father, from Mr. Ayers, a report from Harbor Hall, a report from Ms. Anderson from Pretrial Services, a letter from Ms. Welch herself. I did have a chance to review all of those things prior to the hearing today. Addition to the PSI. Aside from that, are there any additions, deletions, or corrections?
Just an update on the day's credit, Your Honor. Mr. McFalda had run the numbers, and I agree with him.
108, Judge.
Yes, actually I have 109 because there was one day at the initial arrest, and then you have 108 up till through today's date. Or the report says 109.
Okay. Okay. I have 108, but I don't know where does that say that at?
Here, Mr. McFalda, referring to this.
Oh. 36, what's today, but, okay, 109, Judge.
Okay. Any other corrections, Mr.?
No other corrections, and that's just an update to reflect the new sentencing date.
Any challenges to the scoring of the guidelines?
No challenges to the scoring.
Ms. Cope, the people have any additions, deletions, or I'm sorry, Ms. McGregor, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections or challenges to the scoring, Your Honor.
Okay, Ms. McGregor, anything by way of allocution on behalf of the people?
Yes, Your Honor. When you look at this case, the defendant has 3 prior felonies, 7 prior misdemeanors that are on the prior record. But I want to specifically look at those charges, Your Honor. When you take into account in 2020, Ms. Welch had a possession of methamphetamine out of Roscommon County that she pled to. She did 30 days in jail with 1 year probation. During that period of time, she was several bond violations for an additional 30 days. She was unsuccessfully discharged from probation on 5/3/2022 of multiple violations that included new felony behavior. Then when you look further on, Miss Welch's criminal history is fraught with substance abuse. There's OWIs, operating while impaired. But then in 2022, she also had another charge or arrest for possession of methamphetamine as a second or subsequent. That was later pled to a possession of meth, and she received 4 months in jail. Then again, in 2022 of March, she had another arrest for possession of methamphetamine, second or subsequent, and her final charge was a controlled substance maintaining a drug house that she pled to in 23 and did 5 months in jail. After that, she also had a charge for resisting and obstructing. But I want to focus on the drug charges because I think that's important. When you look at community sanction and whether an individual is appropriate to maintain on probation within the community, you have to look at what they have done prior. And in this instance, the court has given, or several courts have given, Ms. Welch opportunities throughout her criminal history and her substance abuse to go to Harbor Hall, to attend Grace Center. And I think notably that if you review the PSI, it said in here that Ms. Welch did attend Harbor Hall and that they requested her to stay longer after the 30 days, and she declined that service. Well, she was on bond out of this charge. She had 2 violations. And I think that's telling, Your Honor. I think that's more telling than anything to say that Ms. Welch is no longer community sanctioned material. Supervision within the community. I know MDOC has made that recommendation of 10 months, but when you look at her criminal history and when you look at what she's done while she's been on bond or on probation for that matter, she's violated. She's violated your bond conditions, your orders through this court during the pendency of this trial, and continued to use methamphetamine. She violated her bond in her first controlled substance case and was unsuccessfully discharged. So community supervision is for people that have the ability to have rehabilitation within the community. There's a punitive sanction to that, but it looks at whether we believe that this individual is appropriate to have community supervision, that those services that community can offer, that she'll be successful on. And she hasn't been. She hasn't been since the period of 2004. So for 20 years, she continues to violate criminal law. She continues to use controlled substances while on bond, while on probation. And I think those are the most telling points in this matter, Your Honor, that when we look at this, her guidelines are 10 to 28. I understand MDOC recommends the bottom of the guidelines. I don't believe she's community supervision anymore based on that. The services that have been offered to her throughout the pendency of her criminal history, she either didn't take advantage of or took advantage of some of them and then didn't follow the recommendations. And I understand you indicated that you received letters from Grace Center and some other places. I guess there was a few of those letters I didn't receive, but I'm not really concerned about that because when I look at her criminal history and her ability to maintain sobriety and be an effective member of the community and not involved in the criminal justice system anymore, I don't think she meets that standard. And I don't believe any longer that she is community supervision. 17 criminal charges dating back for 20 years that are thought with controlled substance and alcohol, along with other things, but we're focusing today on the controlled substance and the use of substances. And so therefore, I'm asking for the court to consider, when you look at these guidelines, I'd ask for the court to consider 18 months. It's the middle of the guidelines. I think she's had sanctions of 4 months, 5 months, 30 days, and none of those have been successful. So I don't think today, if we sentence her to 10 months, that she'll be successful. And I think that she should receive an MDOC sanction and come out on parole, and maybe those services will be more adequate to help her needs. But when you look at, this case revolved around a vehicle driving, and there's several cases of OWIs or having drugs in a car. And so when you look also for safety of the community, which should be paramount for any prosecutor to argue, I don't think her continuing to use substances and being under the influence and driving while she was on bond to get tested under the influence is keeping the Crawford County community safe. And that's why today I'm asking for a sanction in the middle of the guidelines, Your Honor.
Thank you. Mr. Thompson, anything to add as well?
Thank you, Honor. I'd take the opposite position on behalf of Brandy. Brandy's a person who's been struggling with substance abuse. There's no doubt about it, but I'd reject that sort of broad characterization that she hasn't been successful. I think she's been successful in a lot of things. I think she's had a lot of her life go with 2 steps forward, 1 step back. And I think you can paint that with a broad brush and say there have been setbacks along the way. And I think you can also say she's a person who's accomplished a lot of things, who has children that she loves very much, who is a good employee, who has support from her family and from her loved ones, who is a person who still has a lot to offer this community, who is a part of this community. I think when you're looking at a community sanction, you should look at community support. And I think courts received indications of community support. I think Ms. Welch has indicated a willingness to attend rehab and a willingness to not just attend rehab, but to engage in it. And that's what struck me about her letter that she wrote to the court. I thought it was very well written. I thought it struck the right tone in terms of, I think she has learned a lot. I think she has acknowledged a lot of her struggles, but at one point she indicates that even though she's dealing with controlled substance abuse, and even though she's dealing with relapse, that she's not helpless. And I think because she acknowledges she's not helpless, I think the situation is not hopeless. I think she is a person who is growing. I think there have been setbacks. I think there have been setbacks during this case. But respectfully, Your Honor, I think Ms. Welch is a person who would benefit from a community sanction, who would benefit from continued monitoring. I think she's a person who would benefit from being in this community. So I would respectfully urge the court to adopt a community sanction and community supervision as suggested by probation department. I think 10 months is an appropriate sentence in this case. I just ask the court to consider that. Thank you.
That's probably anything you wanted to say. Okay, so I looked at the pre-sentence report and read all the information contained within that. I was well familiar with the facts of this case and this incident. This case has been pending for a long time. It's the subject of a lot of pretrial motions. We had issues regarding, your bond, violations of the bond, hearings related to that. So through the course of all of those hearings, I became very familiar with the facts of this case, your kind of issues, I think, generally. Certainly through the letters, I got more information about your background, you as a person. I take all of that into account along with what the attorneys had to say here today. And, looking at your case, certainly there are mitigating factors here. You're a young individual, you still have a lot of time to seek rehabilitation, to work on getting past this, so it doesn't continue to be a recurring theme in your life. Through the letters that I read, obviously nobody's all one thing. People are all different kinds of things to different people, and absolutely convinced you have good qualities that are brought out through the letters of the people that support you. I'm sure that you're deserving of that support from those individuals. On the other side of things is the side that Ms. McGregor pointed out, which is, there have been a lot of attempts to correct your behavior that have been largely unsuccessful. Two of the facts that stick out to me is that you've had 6 prior jail sentences, but more importantly, 6 prior terms on probation. And so what that tells me is that those attempts have not been successful up till now. That doesn't mean that rehabilitation isn't possible and that you shouldn't continue to seek that. The question for me is whether or not the court should continue to put community, local resources into that, or whether it's time for you to start doing that on your own, because we've tried and haven't been successful. And I think that's where we're at. It doesn't make sense to me after 6 prior times on probation to continue putting you on probation. Again, I think to the extent that you want to continue with rehabilitation, that's something that you're going to have to seek on your own if it's that important to you and it's something that you want to do. There's no reason why the court has to require you to do that. You can seek to do that on your own. And there may be other resources available to you that haven't been available to you locally. But at this point, again, I don't see any benefit to you or to the community in continuing to just do the same thing over and over and over again for the 7th time now. So I do find that a Department of Corrections sanction is appropriate, given your past history, given what happened in this case, including your bond violations. So the court is going to sentence you to 20 months to 10 years in the Michigan Department of Corrections. You have credit for 109 days served. Court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, and $68 state costs. You have the ability to seek an appeal of the sentence, and Mr. Thompson provided those appellate rights to this motion.
Your Honor, the PSI indicates that Ms. Roach is SAI eligible. Would the court have a decision today on that SAI program?
Yeah, I'm not going to have an objection to your participation in the boot camp program. If the court indicates you're eligible, I'll get a notice from the Department of Corrections as to whether or not you actually are, but I do think that the program may be beneficial to you. Again, where traditional probation hasn't, perhaps that may have an impact. So I don't have an objection to that.
Thank you, Your Honor.
Ms. McGregor, anything else from your side today?
No, Your Honor, thank you.
Well, very good. Mr. Germer, you're ready with Mr. Crawford's case. Versus Crawford. This is file number 245358. The record should reflect Mr. Crawford is present here in the courtroom today. Mr. Crawford, if you had an opportunity to go through the pre-sentence report and speak to Mr. Germer about that.
Yes, sir.
Okay. Mr. Germer, is there any additions to the corrections to that report?
No,
Are there any challenges to the scoring of the guidelines?
no, I believe it's accurate score is everyone uses.
Spoke any additions to the corrections?
No, Your Honor, but we do have a victim that is appearing on Zoom that would like to speak today.
Is that Mr. Nichols?
Yes.
Mr. Nichols, if you can hear me, we're getting ready to start the case involving Mr. Crawford, but if you'd like to address the court as part of sentencing as the victim in this case, we're going to need you to turn on your camera and your microphone. So Mr. Nichols, you're going to need to go into your Zoom app and connect your audio. There we go. Okay, and then now you just need to unmute. Thank you. So Mr. Nichols, are you able to hear me okay? Okay.
Yes, sir.
Mr. Nichols, my name is Judge Mertz. We're in court on the record here in Crawford County. I'm conducting a sentencing of Ryan Crawford. My understanding that you're the victim in this case. Is there any statement that you'd like to make to the court prior to sentencing?
Yes, there is.
Please go ahead and do that.
First, I'd like to start by apologizing for not being able to be there in person. I live quite a ways away, so it's hard for us to get up there. But the biggest reason I wanted to make a statement today is there's a lot more that goes on to this case than just a normal trespass and the theft that occurred.
Sorry. My parents were killed out on that property. And they went out onto that property with no regard for my family whatsoever. For what we've been through and what we've been dealing with for a year and a half. I apologize for how I'm acting, but there was an investigation going on to find out what happened out on the property with my parents, and that property was posted. It was fenced off, bright red postings of do not come onto the property, do not trespass. One of the canoes that they tried to steal, my mom's body was 5 feet from that canoe. So we installed cameras because we had never had a problem in 40 years of owning that property. And we put up these cameras, not in hopes of catching anybody, but in hopes of somebody would, if they seen those, they would think better and walk away. He chose not only to not walk away, he chose to try and take my parents' property. He tried to take advantage of our situation. He tried to take advantage of the fact that he knew what was going on that property. He admitted that to the sheriff's deputy. I want to thank the sheriff's deputies for their actions and how fast they found him and his daughter. I want to thank all the people of Levels who stepped up and admitted they knew this guy and they knew him from around town. But the reason we put up the cameras again was not to catch somebody. We didn't want to catch somebody. We wanted to prevent somebody from doing what he tried to do. And the stuff that was taken was stuff that my dad had there for his grandkids. Those canoes that they tried to steal were for my kids. If you look at the pictures, you can see in the picture the defendant taking a boat motor out of a white barrel in front of our pole barn. And my son and I were supposed to be going up there in November. I'm sorry. We were supposed to be going up there in November to finish that boat motor, which he was rebuilding for my son. And with no regard to anybody or anything, he decided with greed of only making a few $100s off an old boat motor, he wanted to take that for himself. And that boat motor means the world to my son. That's all he has to remember his grandfather by. That was the last thing my dad was working on before he died. And to have the indecency to not care and to take things from people that mean so much to them, it breaks our hearts. We've been dealing with enough. Up there to have to deal with this is just absolutely ridiculous. From my understanding, he's got a long experience and history of these actions. I have 2 daughters of my own, and for somebody to do what he did and bring his own daughter into something like this is indefensible. I don't know the defendant's history. I just know what I was told by one of the deputies, and it's lengthy. I hope the court takes that into consideration. I hope the court takes into consideration the situation with my parents. Take into consideration he knew what happened out there. He told the deputy he knew what happened out there. And again, with no regard to me, my family, my children, he chose to take his young daughter and go out there and do what he did. And I hope the court takes all that into consideration. I thank you for your time. I thank you for letting me speak. I was hoping to get through it a little bit better than what I did, but thank you for your time, Judge, and everybody involved. It means a lot to us that you guys are bringing this case to a close for us.
Okay, thank you. And Mr. Nichols, I'm going to mute you just so there's no background noise. Being connected to watch the rest of the proceedings. Okay.
Thank you.
Ms. Colbert.
Your Honor, the guidelines in this case are 0 to 1 because of the 10-year gap. In Mr. Crawford's criminal history, he has 3 prior misdemeanors and 5 prior felonies, but they're obviously more than 10 years old. I think the recommendation for 18 months probation is appropriate. I think the court should order 30 days jail, which is the high end of the guidelines. You know, we have a lot of people that live in this community. We also have a lot of people that come up here and visit and have cabins. You know, it's not good for anybody to have people who just feel fine walking on people's property and taking stuff that's not theirs. I think there should be an element of punishment, and I think the 30 days would be sufficient, given Mr. Crawford's age and criminal history. Thank you.
Thank you, Mr. Grimmer.
Thank you. Mr. Crawford, since the onset of this matter, has been apologetic for his conduct. Mr. Crawford, again, the last time he was in trouble was in 2008, and then, of course, this matter that was pending before the court. Mr. Crawford indicated that there were some other young individuals that met up with his daughter, and there was some discussion about buying some property, which is why he went to the property to purchase things in the property. I think the screw up for Mr. Crawford is that there was nobody present there. There was no money exchanged, and then he took the boat motor, and that's what he admitted to. And then as he drove off with it, I realized he was doing something wrong. Sheriff don't want to drop him off, didn't do that. And left it in the woods, and then I think a week later, a couple of days later, saw that the motor was still there, and then took the motor from there. That's what he pled to. Again, there's no defense to that. That's what he's admitted to, and he admitted that to the police as well. Mr. Crawford, again, you know, is apologizing. I think his intent is to apologize to Mr. Nichols and his family as well for his wrongdoing and his actions. Mr. Crawford also does not live here, and again, has a cabin up here and visits and comes up here. So, in defending this case, there are issues that I can't make sense of either as to why this happened the way it did, and certainly Mr. Crawford doesn't really have much of a defense other than admitting to what he did and admitted that to the deputies when they first investigated this matter as well. Mr. Crawford lives in the Saginaw area. Mr. Crawford indicates that he's going to pay his fines and costs in full today, including the restitution that is owed, so that will be paid for. And then we would just ask for an order indicating that because it is joined in several of his daughters, in her case, in the district court, that would suffice that part of the district court's joined in several liability for restitution as well. So Mr. Crawford intends to make the victim again as whole as possible monetarily as it possibly can. I don't know.
Thank you. Mr. Crawford, anything you wanted to say?
Yes, Your Honor. I would like to apologize to the Nichols family. It was never my intention to them to go to their property to steal anything. I feel sorry for their loss. It's hard to lose a parent, you know, or two, and I've done that myself, and I know it's hard to overcome. My heart goes out to them, you know, and hopefully they can work through, you know, those things. My intentions were to never steal from the family. I was there to meet with people that I believed were from the family, you know, and purchase the items that were offered to me. You know, I never had criminal intent to go there. You hear many times where a family have a tragedy and they argue over money and belongings and stuff. And I just said, well, if these kids want to sell me, I call them kids, they were probably young adults. I never met them. If they're willing to sell me stuff, I'll buy it. You know, they're going to sell it to somebody, I'll buy it. You know, is it, you know, right to do that? No, not really. But that was my intention, you know, was to go purchase items. And I was informed by my co-defendant that she had permission to be there from what we believed at the time was the nephews of the property owner or whatever, the lady. There was supposed to be a lady that was in control of the property. I know now that that's probably not true, that they had criminal intentions of their own, but that wasn't my intention to go there and steal anything. Again, I would like to apologize to the family. You know, my heart goes out to them for their loss, and you know, only time can, you know, heal a broken heart like that. I've lost my family members. You know, my father passed away. My brothers, two of my brothers just passed away. I know how hard it is to deal with loss, and that's, you know, I'm very sorry for my actions. And it wasn't what I planned on at all. It turned out to be something totally different. And I have a family of my own that I support and try to work for to keep afloat. And I just, I'm here to, take my punishment.
Okay. So I did read through the report. I'm familiar with the circumstances of this incident based on the information within that report. There's also information in there about you and your background, Mr. Crawford, so I'm familiar with that as well. I take all that into account along with what you had to say here today. Certainly, Mr. Nichols, I do want to thank you for making the statement that you did. I always appreciate when victims make statements because it gives me a different view of the circumstances. You know, when you read it on paper, it looks like, I think, 4 canoes and a boat motor. But it's certainly, obviously, to you, much more than that. And I think people, when they think about thefts and break-ins and those kind of things, it's a non-violent kind of offense, but that doesn't mean it doesn't affect people psychologically. It doesn't mean it doesn't have an effect on victims. And particularly with property, I mean, people have sentimental value that's attached to otherwise seemingly just normal everyday items. But Mr. Crawford, when you decide to take somebody's property like that, you have no idea what that property means to someone else. To you, it looks like a couple of canoes sitting in the woods. Obviously, we've heard from Mr. Nichols today, and those items were much more to him and his family than just items sitting on a vacant piece of property. So Mr. Nichols, I do want to thank you for making that statement today, because I think it's important for the court to understand all the factors that play here. So I certainly take Mr. Nichols' statements into account as well. Looking at the circumstances as a whole, I was surprised by the guidelines. Frankly, in 12 years, I don't think I've ever seen a 0 to 1 guideline. I think that was a guideline. But that is the guidelines here. The law allows for maximum sentence here unless the court were to depart of 30 days in jail. There's kind of 2 separate versions of what happened here. There's the version that I get from the police report and the PSI, which is you came onto that property and were fully engaged in removing items from that property. There's nothing in that report. There's no evidence that I have that you were engaged in some type of conversation with other individuals or that other people were involved. That's your side of it. I'm getting that from you. I don't think I believe that. I really don't. You can talk to me until you're blue in the face.
No, I hear you.
if you
I
want.
was just gonna say,
You've already talked. and I
Okay,
gave you
sorry.
full opportunity to say everything.
Yes,
This is
sir.
my turn to talk.
Yes,
We're
sir.
not gonna have a debate.
No, sir.
You just need to listen for now and think about what I'm saying, which is I just don't believe that. I don't believe that somebody who's your age, 51 years old, with plenty of life experience, certainly plenty of criminal involvement, I don't believe that you were engaged in some kind of innocent conversation with individuals that you truly believed represented Mr. Nichols and his family, and that you were planning on buying things. I think that you thought this was some unmonitored property that you could go and grab. I don't think you understood how important it was to the Nichols, and I think you saw an opportunity and you were going to take advantage of that and have your daughter help you. That's exactly what I think happened. And I think all the common sense evidence here points that out. Somebody of your age, your experience, your involvement previously with the criminal justice system doesn't make sense to me. You really thought this was just an innocent thing. I'm going to take this stuff and I'm going to pay for it. So I don't believe that's true. I think you went there with the intent of removing this property or not caring about it. And I think there's a penalty to be paid for that. I think if I had more than 30 days at my disposal, I certainly would impose it. I think your incredible story here, I think the time is appropriate because I don't think you're taking responsibility here. I don't think you have at all at any point during this case, including during the plea process. I'm trying to avoid that. And so that, along with your actions, I did warrant the jail sentence of 1 month. So the court is going to sentence you to 30 days in the Crawford County Jail. You have credit for 2 days served. The court also finds that probation is appropriate to monitor you and supervise you for a period of time. But the court is also going to place you on probation for a period of 18 months. And adopt as the conditions of that probation, all the terms and conditions listed in this report. The court is going to order payment of restitution in the amount of $538.20. That's to be joint and several with H. Krugelke. It's joint and several, Mr. Gurmurthy. So if Mr. Crawford pays that entire amount, then I think by the virtue of the nature of joint and several restitution, that she's not going to be liable for it. The court is making it joint and several. The crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, and a $30 per month supervision fee while you're on probation. You do have the ability to seek an appeal of this sentence. Mr. Gurmurthy is going to provide you with papers that explain to you what your appellate rights are. Have you working on that?
I have, Judge, I've given Mr. Crawford a copy of his appellate paperwork and reviewed his appellate paperwork with him.
Just as a housekeeping matter, I did reach out to district court to ask them if the co-defendant had paid anything on restitution prior to sentencing today. She had not, so if she's gonna pay that full, I will let district court know so they can amend her price cost.
We just asked him that he paid in 30 days once he's released from jail. Then was the pay today. I don't know if that's possible at this point.
I'm not going to put a time frame on it. I usually don't. So the court's ordering restitution. Mr. Crawford, you're in custody of the county at this time.
Yes, sir.
Next matter is People versus Heather Merchant Hart, file number 255384.
Sierra Coke on behalf of the people.
And we're on behalf of Ms. Hart, who's present and point. Yes, the client is going to be entering a plea pursuant to an agreement.
Tell me the term for that.
I had, we reduced them to writing.
The offer is to attempt R&O, which is attempt count 1, and added count of OWI high BAC. The PAC code is 257.6251C. Both of those are misdemeanors.
Again, that's added 6.
It will be added count 6.
What is that again?
OWI high BAC.
That's the 93-day misdemeanor.
It's 180 days.
Sorry, what?
It's 180 days.
Ms. Merchant, Hart, we had an adequate opportunity to speak to Mr. Berman about this plea arrangement. Okay, and what we've discussed here on the record, is that what you discussed with him? Is it the same? Is that how you want to proceed today?
Yes,
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Lower your hand. Ms. Merchant Hart, are you currently on any probation or parole?
Sure.
She's on bond for this.
Right, okay. You don't have any other cases in any other courts
No.
here? You understand that by pleading guilty to attempted resisting obstructing, the maximum penalty you could face for that charge would be up to 1 year in jail?
Yes, Your Honor.
And that operating with a high blood alcohol content, the maximum penalty you could face would be up to 6 months in jail. Do you understand?
Yes, Your
With those two maximum possible penalties in mind, what is your belief on those charges? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yeah, sure.
Can you tell me what's going to happen to those rights? Are you pleading?
They're gonna go away, Your Honor.
That's correct. Waiving them and giving them up. Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sure.
Are you pleading guilty because you are actually guilty of each of these charges?
Yes, sure.
The information I have indicates this happened back on December 13th of 2024. Is that the correct date?
Sure.
On that day, had you been consuming alcohol?
Yes, sure.
And after you consumed the alcohol on that day, did you operate a vehicle on a federal highway in Crawford County?
Sure.
And did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, sure.
And was that above a 0.17?
Yes, Your Honor.
Do you remember what that level was?
It was 0.212.
And do you have any reason to doubt the accuracy of that test? Had you consumed enough alcohol that day that you believe that you were unable to safely and normally operate that vehicle?
Yes, sure.
And did you come into contact with an officer from the Crawford County Sheriff's Department on that day?
Yes, Your Honor.
Was that officer wearing their uniform?
Yes, Your Honor.
Did you know that they were performing their duties as a police officer at that time?
Yes, Your Honor.
Did that officer give you some commands or ask you to do something that you failed or refused to do?
Yes, Your Honor.
Okay, what happened?
Your Honor, the officer asked me to step out of my vehicle and I refused.
Okay. And did the officer ask you to do that as part of an investigation into an alcohol-related driving offense? Was she investigating your driving at that time?
Yes, Your Honor.
In other words, she just didn't randomly come up to you and tell you to get out of your car.
No, Your Honor.
And that happened at the same location where you had been operating your vehicle on federal highway.
Yes, Your Honor.
Ms. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Burke?
Yes, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
I am likewise not aware of any.
Ms. Koch, are the people satisfied that the court has complied with statute, court rule, and taking it this plea?
Yes, Your Honor.
Yes.
Ms. Merchant Hart, the court finds that your plea is knowing, voluntary, to accurate, or is satisfied there is a factual basis to support a finding that you are guilty. Each of these charges, the court will accept your guilty plea as the whole. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Mr. McDowell to set up a pre-sentence report. It's important between now and then that you follow through with that and that you stay in touch with Mr. Vernon, your attorney. Ms. Koch, anything further we need to address today?
No, thank you, Your Honor.
Nothing else.
Thank you. That's all for today. Yes.
What? Yeah? Okay.
Yes. No, that is. Mr. Duval. Yeah. Is Mr. Duval on the way?
That's right here.
So the probation.
Okay, I'm gonna go meet him right back there.
You need a chance to talk about that.
I do, because I don't think the new file that just got bound over is, it's here. Okay.
Mr. Trush, I just want to check in. Are you signing in for the arraignment on Mr. Duvall?
Yes, I am.
Okay.
Yes.
Are they connecting on video with him, or is he going to be brought up?
On video.
Mr. Trush, Mr. Duvall's going to appear by video from the jail. They haven't connected yet, so if you could just stay on hold for a minute.
I can do that. Thank you.
Thank you.
Yep. Gotcha, yep.
Hang on one second.
Okay, do we have Mr. Duvall there? Mr. Duvall, can you hear me?
Yes, sir.
Okay. All right, we'll go on the record in People versus Larry Duvall. This is District Court file number 2517825. And sir, your name is Larry Duvall, is that correct?
Yes, sir.
And am I going to be assigned to this case? Is this a?
Yes, you already have.
Is it you? Okay.
Yes, yep.
All right, so for the record, I'm sitting on this case by assignment here. Mr. Duvall, you're before the court today for arraignment on one count felony charge. Do you understand why you're before the court today?
Yes, sir.
Okay. Mr. Yeah, go ahead, Mr. Trush.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Duvall. I had an opportunity to discuss the complaint with him
we'd waive a formal reading of the complaint and stand mute to the charges. He is hiring my office to represent him, and we would be prepared to waive the 21-day rule today.
Okay, so you're gonna be retained, Mr. Trush?
Correct.
Okay. Right, so the court will enter a not guilty plea on behalf of Mr. Duvall with regard to count one. Mr. Duvall, has Mr. Trush gone through all your rights with you?
Yes.
Okay, and you understand that if you can't afford an attorney, you would have the right to have one appointed for you at public expense?
Yes, sir.
But at this time, you're going to retain or hire Mr. Trush to represent you, is that correct?
Yes, sir.
Okay. In terms of bond pending the next hearing, Ms. Cope, if you will take any position on that?
Your Honor, the allegations in this case involve Mr. Duvall touching a 14-year-old's side of her breast and putting his hand at the edge of her waistband at sort of a family neighborhood function on New Year's Eve. He has limited criminal history. It is very old. His criminal history is from 1994, 1995. He's had no other such allegations regarding CSC or anything else. Those were drug cases in the 90s. I defer to the court on the amount. Frankly, I generally don't know the amounts always set by the court, but those are the facts. Thank you.
Thank you. Mr. Trush, anything on behalf of Mr. Duvall regarding bond pending the court's next hearing?
Yes, Your Honor. So my understanding is similar to the prosecutors in terms of his prior history. He did report to me he had some things some time ago. He's a longtime resident of the community. He owns a home here. He has stable work here. He acts as a caregiver for his father. I don't think he presents as a flight risk at all. In addition to that, he turned himself in on the warrant. So he contacted me when he knew it was out there. We made arrangements for him to turn himself in at the jail and such. So I don't think he presents as a flight risk. I think conditions can be used to mitigate any harm to the community or risk of harm to the community. I would suggest to the court a $5,000 cash or surety would be an appropriate amount of bond.
All right, I do find that to be a reasonable amount of bond, given the statements of all counsel here on the record. And that actually is the amount that I was writing in. So I agree with Mr. Trush that that's an adequate amount to assure Mr. Duvall's appearance at future hearings as well as public safety. The court is also going to impose all other standard terms and conditions of bond. The court is going to impose no contact with the complaining witness in this case. I don't want to put that name here on the record because that is a minor individual. And then the court will also require that Mr. Duvall, if he posts bond, report to Ms. Anderson at pretrial services, which is also indicated on the bond form. The next court hearing, Mr. Duvall, will be on April 21st at 3 p.m. That's for a felony pretrial. And then the court will set this for preliminary exam on May 15th at 9 a.m. The court will provide written notice of the date and time of both of those hearings to counsel and to Mr. Duvall. Ms. Cope, anything else we need to address on these files today?
No, thank you.
Mr. Trush, anything else we need to address from your side?
Not today, thank you.
Yeah, I should make a record. I do know Mr. Duvall not well. I've seen him at a couple of community events in town. I talked to Mr. Trush about it. I will not be disqualifying off the case. I don't know him like in a personal way.
Okay, thank you. Okay, that's all for today. The court is going to disconnect from the jail at this time and I'll process the bond paperwork right now.
Thank you.
Thank you.
Did you want the bond?
Just click off. Let's think about it. Yep.
Okay. Court files versus Thomas Hill. We have two different files. Well, two set for today, that's right. Two set.
Correct. The third one that you just got found over on Tuesday, I didn't send that to you. And that does also not have the report date.
So the files we're addressing the docket today are 24528 FH, that's the probation violation file. And file number 255386 FH. We may also be discussing the newly found over file, which is 255392 FH. I could have counsel for your appearance.
Sierra Coke on behalf of the people.
Thank you. I'll let you go. Mr. Hill.
Record should reflect Mr. Hill's present here today. Mr. Grimmerty, how did you want to proceed?
There's the three files, one's a probation violation. I would ask that the probation violation file be adjourned until we resolve the underlying two files. It was a violation stemmed from those new charges. The newest file was just bound over 2 days ago. It was set for next week. I had it moved to district court to try and get them all together. So they're all here together now. So I would ask the two new files, it's our first status conference, we adjourned for 30 days with the plea cutoff. Mr. Hill received some plea offers. I think he needs some time to think about it. He's indicated to me there might be a defense at least in one of the files. So he has to give me that information. He still hasn't been able to do that. And then I'd like to address bond, because I think Mr. Hill's posted bond on one of the files, but he can't post it on the other. So if we can address it, because I'm able to post bond. I'd like to revoke bond, so he's getting credit for all the files as well.
As to the adjournment of the probation violation, Mr. Medella, is there objection to that?
No objection.
As to the other requests, Ms. Coe?
Your Honor, I have no objection. The plea offer will be pulled at the next hearing, but it did just get bound over, so it kind of makes sense for him to have some time to go over all of them with his attorney.
Okay, so the court will set the both new felon, or both felony files for a status conference at its April motion day. The court will adjourn further hearings on the probation violation file for 90 days. I'll address it sooner if we need to, but that'll be a control date to address the probation violation to the extent that the felony files haven't been resolved by that point. In terms of bond, you know.
The 5392 case, he paid 10,000 surety bonds. That bond was posted through a third party poster. That was $10,000. Correct. The new bind of 5392 is a $10,000 bond. Do you want me to check the probation violation case?
But it sounds like Mr. Hill is not going to post bond on the loose file.
That bond was also posted by the same third party poster that posted it in 5386.
So in the probation violation file and the 5386 file, there are bonds posted. So I want to ask to have those revoked.
I would ask those to be revoked. I think I asked Ms. Cope if she would agree to revoke it from the date of when he was incarcerated. I think it was just 2 weeks ago. I didn't hear an answer from Ms. Cope, but I would ask that we revoke his bond so he's getting credit for funds.
You're right. Whatever the court wants to do is fine with me. I don't object if that's what the court wants to do.
Okay, so I'll ask that you prepare a stipulation in order revoking the bond as of the date of incarceration and submit that to the court.
I will.
Just on a side note on this case, I have spoken a couple different times with third party poster. Apparently he posted titles to vehicles for him. So with this order, am I allowed to release that bond so that Craig's can release the titles back to that defense?
I would think so.
I would think so too.
Okay, just making sure. Thank you.
Mr. Hill, did you have any questions?
With that
bond being revoked, does that money go back to him or does it go back to you guys? It goes back to him.
Well,
So there's no money. It was posted through a surety company. So that copy of that order would go to the surety company and then they would release whatever collateral John posted for you.
Okay.
okay, that's all for today on these cases, and then Mr. Hill will be brought back for your hearing. You have a motion to terminate a personal protection order.
Yeah.
Set for 2:45, so you'll be brought back to the court for that.
I had a question. I got a $25 bill for that. Like, what does that mean exactly? I guess. Right now I don't have the money to pay it.
You'll have to talk to the sheriff's department. They did the service for you, so you owe them.
Also, I owe the sheriff's department.
That would be for the service to serve the other side notice.
Okay, okay,
So,
okay.
so Judge, I did not know that the hearing was today.
Yes.
I have to talk to Mr. Thompson in Cruz's office. And I would just ask the court if, because I don't know what that says, I'm not on the PPO file. Statements are being made, or Mr. Hill made statements that can be used against him. In a criminal matter, I think we have to take some caution.
Well, yeah, you may want to have that conversation.
So I'm going to have that conversation with him as well, and I would talk to Mr. Cruz's office. If I'm able to, or if I get appointed with that, could I appear by Zoom at that point?
Yes.
I'll talk to you before we go on the back about that issue. I did not know that.
Okay.
Yeah, it's Mr. Hill's motion to terminate the personal.
Okay.
protection order. And that is with regard to who's the petitioner.
Erica Geary.
Right, and Erica's the victim in the domestic violence, the new case that just came up. But there was a no contact order in there. So yeah, I will talk to Mr. Hill.
That's not for me.
Right.
This should be off the record, so you guys.
I will talk to Mr. Hill.
Okay. Mr. Grimmerty, I would only ask if for some reason that Mr. Hill decides not to proceed with that based on your advice, but.
I'll let you know.
You know.
Thank you.
Okay, that concludes the court's morning docket. The court will be in recess until 1:30.